provide services for 56 tribes in the Bethel region. Thank you for inviting me.
Technical problems. Hold on. We're not connecting.
See, it's not showing the same as what's showing on our computer.
All right.
Which one?
We'll go back.
All right. There we go. Okay, thank you.
That was
All right. So this training is actually sponsored by the Oglala Sioux tribe. The Oglala Sioux tribe is covering all the costs and expenses of the training, and it's to try to educate landowners in the community on trust land issues. Okay, we're going to cover sort of Aboriginal title. What is title to land? We're going to cover some aspects of BIA management. Early U.S. Supreme Court cases. These cases are really important because they shape the relationship between Indians and the United States. We're going to cover a few of those critical cases, and then sort of where we are today. What is the status of Indian trust title? Okay, we're going to start with some really basic old history way back. So if you're a historian and you studied any of this, you know, this is probably recap, but this is, it's important to understand sort of where we started as Native tribes in this country on land and our ownership. So early on, all the colonists that first came to this continent on the eastern seaboard, they actually purchased land in America. They did that through treaties with tribes, and that was actually based upon an understanding that the tribes actually owned the land. So when the early colonists got here, their understanding was that we as Native people owned the land, that we actually had sovereign authority, that we governed the land, and that when they acquired land from us, they were negotiating with a governing authority over that land. So the tribe was considered sovereign. The tribes at that time on that eastern seaboard were considered sovereign, and that they had authority to govern the land, which meant also that they owned the land. They believed that the Indians actually owned title to the land. And then we're going to jump forward, and as you know, there were quite a few years that we were under British rule. Before the Constitution, before the Revolutionary War, we were under British rule. And interestingly, under British rule, there was a proclamation by the king that all the settlers should not try to settle and move beyond those mountain ranges, the mountain ranges on that eastern seaboard, the Appalachian Mountains, that those lands were reserved for the tribes. Those lands were reserved for Native people. And that's actually a proclamation from King George, who was when we were under British rule. Nobody talks about that. It's not in your school books, but that was probably one of the critical reasons for the Revolutionary War, because the British did not believe that the settlers should go beyond those mountain ranges. However, we did have a Revolutionary War, and we adopted the United States Constitution in 1789. So after the war, and what the Constitution said was that the new nation vested Congress with the authority to regulate trade and commerce and to make treaties with sovereign Indian tribes. Interesting that the term sovereign is used there. So we started out being recognized as sovereign entities in the Constitution. We're going to talk about lots of changes to that as we move along through history. And then there's a real, I guess, kind of a telling letter. When George Washington became the president, he explained to the chief of the Seneca in response to a letter that was written by the Seneca that only the general government, the United States, and not independent states could purchase land from the Indian tribes. And the Senecas had actually sold land previously to the colonists, and so there was now a doubt that was cast on all those early treaties that were between the tribes and the colonies. So there was a lot of a doubt about who had title to the land, and there was kind of a limbo period of time after the Constitution went into effect. I will add research on this letter because it's a famous letter that George Washington wrote to the Senecas, and it basically it starts the whole thought that we aren't really sovereign, that we didn't really own the land. It starts that. But this letter was actually in response to a letter that the Senecas wrote and said, we need protection because we were exploited in some of our land deals with the colonists. So you can start to see that double-edged sword between protection and sovereign authority, sovereign governing authority. So you could start to see that. So then Washington wrote back to that letter, and this is what he said. So, okay, so we then move into these three cases that really lay out the foundation of our relationship as Native people to the United States and basically our governing authority of our land. The most famous case in regards to land is Johnson v. McIntosh. This is from 1823. Really important that you use your highlighter and highlight 1823, because 1823 is long before your treaty dates. This is way preceding your treaty. So the United States was taking action in their courts back east while we were still pretty much nomadic people out west on lands that we believed we owned. And this first case is Johnson v. McIntosh. And here, Johnson was the plaintiff. McIntosh was your defendant. They were having a fight over title to land that they got from the Indians, basically. So the plaintiffs went to court to have those land grants that they got from tribes prior to the Declaration of Independence recognized by the United States. So they went to court and said, hey, I have title to this land, and we got this land from the Indians before the Declaration of Independence, and that title should be valid. And we think the court should rule that our title is valid because it was before the Declaration, and we bought it from them. So this went to court, and this is actually the most, I think, devastating court ruling that we probably have. Well, there's probably been some other terrible ones, but this is a very pivotal foundation of our relationship with the U.S. The court ruled that the tribe had no power. They had no independent power to give title to the land. They're saying that they couldn't give land to private individuals based on the doctrine of discovery. And this case then legally justified extinguishing Indian title to the land, saying that you didn't have any title to the land, you Indian natives that were here, and that this is what established that congressional plenary power over Indian affairs, that plenary or, BIA, United States oversight, Congress oversight over the Indians. It all started here, 1823, with this case. So what is the doctrine of discovery? I'm sure a lot of you have, heard about the doctrine of discovery. There's been a lot of discussion and debate about that. But the doctrine of discovery, and remember, before I go there, usually when the Supreme Court adopts a law, or usually when we pass a ruling, when they make a ruling or we adopt a law, it sort of affects from that point forward. And we don't really have laws that say, oh, we're going to go back all the way backward. Here, with Johnson v. McIntosh, they said, you know what, you never had title to the land. You might have thought you had title when you did all of those exchanges with the colonists, but you never had title. And the reason you didn't have title is because of this doctrine of discovery. And the court ratified this doctrine of discovery. And the doctrine of discovery is based on the Christian view that non-Christian people are primitive and heathen, and thus the United States was entitled to civilize and protect the tribes. This is the viewpoint that forms that foundation of the guardian to ward relationship that the United States and the tribes have even today. And this doctrine of discovery was widely practiced around the world, and it was considered culturally racist. It's a racist type of, doctrine. And when the new country was formed, a lot of that European cultural racism was supposed to be left in Europe, and they were going to have this new world. But actually, they continued the European cultural racism right here, and we're the victims of that. So it said that it justified that the U.S. is the discovering nation, and they're able, because of that, to overtake and possess all the lands and property of the conquered nation. So that's a pretty devastating ruling that came down back then. And of course, when we had all of our chiefs out here, all our people in the West, they had no idea about this. How could they? And how could they, they were out here. And it wasn't until many years later, 40-some years later, that we started doing treaties in the West. But this was the case law of the United States by the time they came out here for treaties. Want to add anything?
No, just that's the philosophy in terms of their viewpoint when they went out, right? Like their sense is, hey, we're in the right, we're helping you, we're civilizing you, we're transforming you. That there is this inherent presumption at that time in terms of, as Christians, our relationship with the land, our relationship with this country is superior because we're on a mission from God.
Yeah. All of this is justified through Christian beliefs. And, and like Georgette said, that's how they ratified it. We're doing this because we're called to do it by God. And so that's a tough pill to swallow, I think, for a lot of us. Okay, let's go on. You guys stop me if you want to stop, and, if there's anything that you want to add or ask, please do that.
So the next big case we have that looks at the Indian relationship with the United States and the new government is Cherokee Nation v. Georgia. At the time Andrew Jackson had become president, Georgia had a very tense relationship with the Cherokee Nation, which was a really active, large nation in their boundaries. Because Andrew Jackson was viewed as so unfriendly to the tribes, they thought, okay, here's our opportunity. So they went in and argued that once they became a state, that the Indian title, that land that had been set aside with the Cherokees, was extinguished and became part of the state. What the Supreme Court ruled was that the Cherokees were a domestic dependent nation with the right of self-government, that they kept the inherent powers not otherwise reserved by the U.S. over their internal affairs and territory, that they occupied the lands held by the U.S. and that it was for their benefit, and that the tribal relationship with the U.S. was that of a ward to his guardian. And that's the foundation of the trust status Okay, go back. This is a mixed bag, again, for tribes. It established and really, it established that we still had those lands, so Georgia was not successful. However, you again see that diminishment in the understanding of what it means for us to be sovereigns. We're not sovereigns. In the Supreme Court, in the law's eyes, we are domestic dependent nations, and we retain those sovereign powers that are not otherwise taken back by the United States. That's what that domestic dependent nation stands for.
So this case is really where you hear the term quasi-sovereign. This is where that comes from. So we're not necessarily a full sovereign. We're sovereign from the state, but we're not sovereign from the U.S. And so that's where quasi-sovereign comes from. And they're really saying, yes, you're sovereign, but you can only be sovereign over your own territory and your people, rather than being like a full governing authority. This case limits us to a more narrow idea of sovereignty.
So after this, Georgia continued, in the next case with Worcester v. Georgia, they continued to push on their authority. Georgia passed a law that said our state residents can't go into Cherokee territory unless they get a permit from us. There was an ally, a minister, who was willing to be a test case, and he basically went into Cherokee territory and said, when I'm in Cherokee territory, I'm governed by the Cherokees, not by you, state of Georgia. They decide whether I can be here or not. And so he was convicted of violating the state law, and it went up to the Supreme Court. The court ruling said that Cherokee is a distinct political community within the boundaries of their land where the laws of Georgia have no force. So this is the foundation of that separation that tribes have from the state. It was, in terms of how we operate now, it was a good recognition and outlining of our jurisdiction. I will tell you, this is where, Andrew Jackson is famous for saying, well, the Supreme Court passed it, now let them enforce it. Georgia did not release that minister from jail despite this ruling, and said that they would release him when he changed his plea to guilty. And so he spent several years, even after this ruling came down, in jail, in prison.
I shouldn't say this, but Andrew Jackson's picture is hanging back up in the White House, as you've all heard. Yeah. All right. Okay, so those are the three foundational cases. Those are three very critical cases. And even today, when we're going to write a brief where we're arguing against the state for an incursion on the tribe's sovereignty, we go all the way back to the cases, to the Worcester case, and the Georgia, that whole framework. We still use that. That's still good law. It's still pivotal, important law. We don't like Johnson v. McIntosh, but our whole process of managing land is based on the fact that we don't have title to it. We don't have title to the land. The United States does, and that's the development of the whole services to manage those lands by the government. Okay. So what happened? Where are we with title after those three cases? This is way back in 1832 that this was decided, that the tribes do not have title to the lands, and we can't alienate the land, which means we can't sell the land, we can't convey the land without U.S. approval. The United States has plenary authority over tribes, including the role of trustee. So that means that the United States is really overseeing all of your Indian affairs. They are authorized under those cases to take that role. And then third, that the tribes are domestic dependent nations that retained quasi-sovereignty with the authority to govern within their own lands to the exclusion of the states. So that's where we were after these three cases. And that was our status in those years before we entered into treaties. I mean, so we had a misunderstanding. I believe, when we were all at the table to do treaties. All right. Go ahead.
All right. So as a new nation, with the sense of, the doctrine of discovery, there was also this sense of settlers that God wanted the United States to grow in terms of its size, that again, this was a mission from God. It was the manifest destiny. And that was incorporated in the general United States policy. Their sense was to acquire land, more land. So you had the Louisiana Purchase around this time period. And as this expansion happened, there were conflicts, obviously, with the tribes that were out there that, were using their land, living where they were, with these colonists who felt like it was their entitlement to be out there. So reservations were established to restrict the movement, settle nomadic Indians into permanent localities, to cope with that expansion and to minimize physical conflict so that that expansion could occur. Through early peace treaties, the tribes ceded land to the U.S., but there were parcels that were reserved, and that's where the term reservation came from.
Any questions? You guys are really quiet. Any questions or comments on anything? All right. Okay, what are the methods that were used to create reservations? A lot of reservations were created by treaty, and treaty making ended in 1871. But lots of reservations, including this one, were created by treaties. There were also acts of Congress that created a treaty. We have executive orders that created reservations, and those are reservations that were created a lot later, after 1871. Some of those clear all the way up into the 1920s and 30s that were created by executive order. Also, combination of the above. There are reservations that were patented to tribes by the U.S., mostly all those lands down in the Southwest, because those land grants were made to those Indians under the Spanish land grant, and then the United States recognized them. So their land is in a bit different status. And then there may be more tribes than this now. We've had a few more that were recognized recently. You might know that. I don't know, BIA, if you know. Is 574 still the number? Is it a little higher? I think it's a little higher. That's the number they have on their site. Oh, this is the number on your site. Okay, 574 Indian tribes recognized by the U.S., 326 reservations in the U.S. with 56,200,000 acres within their boundaries. That's the land that's left under Indian control, is 56,200,000 acres.
I have a question.
Yes.
Prior to March 3rd, 1871, most of our treaties are prior to that, like the 1868 treaty and the 1851? Yeah. And some of them, like my grandfather, were part of that treaty, part of that 1868 treaty. And then there was a couple cases here on the reservation, that were won, using the 1868 treaty, Article 1, the 1868 treaty. And so that was using just Article 1, but there's 17 other articles that are part of that treaty. And I don't see anybody bringing forth those other articles, in court cases. I don't know, maybe they have them, but do you know of any?
We didn't research litigation efforts, on treaty claims. You do have a lot of ongoing litigation, unresolved issues from the taking of the Black Hills, for example, which we were going to cover a little bit. We're just going to point you in the language. The really hard thing is they did, after all of these reservations were created, they did have an Indian Claims Commission. And the Indian Claims Commission was only operational for a period of years. And it said that if the Indians were not satisfied with some of the takings of land, other concerns with their treaties, they had a period of time to bring those cases to the Indian Claims Commission. But if you didn't, you're foreclosed. There's been a lot of debate about that. There are tribes that got payments, that got compensation, that did have successful cases in the Indian Claims Commission period, but a lot of them didn't. And so, you know, the really hard thing is, are we time barred from bringing treaty claims? In some cases, we might lose and say we are time barred. There are other situations. We've had a couple big treaty claim cases that went very well recently. The big hunting case under the Fort Laramie Treaty, the Herrera case. So that basically was a good interpretation of old treaty language. So it's really hard to say, and you really have to have a very detailed, fact-specific case to try to move forward with a treaty claim.
Do the Crow tribe, do they have the same 1868 treaty as we do?
They have the same treaty that you do.
Were they at Fort Laramie?
And the hunting language is the same.
Oh, that, oh, okay.
Yes.
Okay.
That 1868, it's basically you can hunt in all the open and unclaimed lands under that language in the 1868 treaty.
So do they still hunt up there?
We're in a fight still.
Oh, that?
Because what the Supreme Court said in that case is, yes, we're going to recognize that treaty right, that a tribal member can hunt in all open and unclaimed lands that were within their Aboriginal hunting area. For you guys, that's all over, but that's what it said. It said, but the state of Wyoming still has the right to enforce conservation of game. And then it also said, and we're not going to define what open and unclaimed means. Clearly, open and unclaimed is not private property, but the questions are, is a U.S. Refuge, a U.S. Fish Wildlife Refuge, is a national park, are those open and unclaimed? So those two questions are still out there. They weren't resolved by the litigation. So what we're doing, though, is we're trying to approach the state of Wyoming and reach an agreement on where we can hunt in Wyoming.
Okay, thank you.
All right. Anybody else, anything else on your mind before we move along?
So like Nachel said, we're going to talk a little bit about how your territory, now that the BIA recognizes your boundaries, were formed. We understand that there is a lot of contention about the history of this, what has the legality of some of these actions. However, this is going to go through what the BIA currently recognizes. So, you know, you do have a very active treaty commission. Mario Gonzalez has worked on these claims for you. So this could be a whole PowerPoint presentation in itself. So we're not really going to get into like where that stands. We just wanted to go through this so that you knew where the boundaries were and how the boundaries were diminished. So this was, you know, a starting point of the general territory, and then, like you said, there was the Treaty of 1851. It defined the territory. Again, a lot of these treaties, you know, you didn't have surveyors out there who could, so a lot of these territories followed the rivers. And so that's how it's described. And so this is where your territory was set out in the 1851 treaty. We have a map here. If you look, it's all the colored portions. The other colors reference some things that happened later, but the colored portions are what was set out early in 1851.
So actually, and this is the Great Sioux Nation. This is for all of the, if you read it, it defined the territory of the bands of the Teton Division. So, this is not just Oglala, but this is the Great Sioux Nation. And then later, the Great Sioux Nation was divided up. And we'll go to that.
So then in 1868, it had the boundaries for the 7 Teton bands, again, like Major was talking about, the Great Sioux Reservation. Your territory was reduced at this point. And then, let's see, why didn't it go to the map? And it went down to that yellow part, right there. So the internal yellow part is what 1868 took you down to. And then there was the seizure of the Black Hills in 1877. Like we talked about, reservations were created not only through treaty, but through acts of Congress. And in 1877, they ratified and confirmed altering the boundaries, and that's where, again, you have that smaller part that was in yellow, and they carved off the part that's in blue. So the green part, the green and the blue part represent what was the yellow part in the other map, and then they carved off that blue part in the 1877 Act. Yes, they did add some acres up on the north part. Sorry, I got away from the microphone. They did add some acres up in the northern part, but the big controversial move was carving off that blue part. Then there was 1889 transfer, and the division into the various, when you got divided up as Oglala, but you have, again, we just wanted to put the land description that was contained in the 1889 transfer. And then this map kind of shows where you're at now, and down at the bottom, like, so originally what the Great Sioux Nation looked like in the 1868, what was lost in 1877, and then how you're divided up now. So this is probably, again, there's some areas on the lines, but this is a generally accurate depiction right now of land.
And you do know, obviously, that there was litigation, United States versus the Sioux Nation, over the Black Hills taking. That still remains in contention, as you all know. Okay. All right. So let's move forward to fractionation. All right. But before we get to fractionation, you have to understand how we got there. Allotment. Miserable allotment, though. Okay. But we wanted to put this up. So think about where we're at in history. We were first considered sovereign nations. We tried to sell land. We did negotiate that as governments. We lost all of that with the United States in those 3 cases. They decided that we didn't have title to land, and so they had to start enacting laws right away to authorize them to take control of the title that they had. They had the title, we have the right to be occupying the lands. So one of the first acts that was passed was way back in June of 1834. It's 25 USC 177. We still quote that all the time when we're talking about trust land. Yes.
Ma'am, are you saying it's okay to occupy property that doesn't belong to you?
No. But what
That's what you just got done saying.
we're saying that the United States says they have title, but they've authorized Indians to occupy the land that they have title to based on the reservation negotiations.
And based on a reservation, even inside of a reservation, there's boundaries set to individuals. And when boundaries get intercepted on, you're gonna have conflicts.
We're going to get to that. We will get to that. All right. All right. So this is an old act, though, that just lets you know that right off the bat, 1834, it said to tribes, no purchase, grant, lease, conveyance, or any title claim to Indian land is valid without consent of the U.S. And this statute applies to all individual lands and tribes in the same manner. So this is old law that authorized basically the BIA to ratify, approve, manage trust land transactions. Okay, after the reservations and before allotment, this is before allotment, we actually had communal ownership of our Indian lands. Everybody owned all the land together. We didn't have independent property rights. That was a foreign concept to a lot of our Western tribes. Our Western tribes didn't have parcels that they considered their own. That was actually not within our culture, but it came from Europe along with the colonists. And all the reservation lands were to be held in trust. They were in trust. That means the United States was going to oversee them for the benefit of the tribes, for all the people. However, go ahead on that.
So around this time, like shortly before allotments, around this time you had the Civil War with the United States. The Civil War was very financially devastating for the country. It diminished the citizenship of the country. And so what it really did was it started to restrict, before that point, based on their manifest destiny and doctrine of discovery, they were wanting to expand U.S. territory. They didn't financially have the ability to do so after the Civil War. And so it ended their external acquisition of trying to buy land from other colonizing nations. And so what happened, you still had settlers moving west. You still had colonists who wanted to own their own land, have farms. And so it changed how they started looking at land and where do we get land for our colonists if we're not buying outside land from other countries anymore? The reservations. And so they started looking inward to the current territory, and that's what they viewed as unused land or available land.
Okay, so that's sort of an underpinning and a precursor to this whole concept of allotment.
Oh, shoot, one more. Oh.
Yeah, go ahead.
So the other thing that was happening, and I guess we can talk about more in the next slide, is we can talk about the ratchets and stuff, but we'll talk on this slide.
Okay, so we're now getting to the point where the United States, like Georgette said, they were looking inward to really figure out a way to get colonists more land. There was really, that is an underpinning to allotment. So it said the purpose of the Dawes Act, very famous Dawes Act that started allotment, was to help the Indians become self-sufficient, to promote agricultural production, to replace dependence on the federal government, and to make Indians tax-paying citizens. But really there was an unstated purpose, which was to start opening up these reservation lands for non-Indian use, and the General Allotment Act did include language that surplus lands after allotment could be sold or used for non-Indian homesteading. And this is a period of time when you need to think about what was happening to all of us. We'd all been moved onto reservations. 1868 is your treaty date. That's the Fort Laramie Treaty that affected a lot of the Western tribes. When we got on reservations, these are years where we were starving to death. These are the years that we had kids that were hauled off to boarding schools. I know that, I believe it was in 88 or 18, anyway, I know that we represent Fort Peck, and we've done a lot of work at Fort Peck. And when we did a research effort on their land, they had like 900 people die of starvation just in one winter. And it was partly because at that time, we were dependent on rations. You were dependent, you couldn't hunt. You know, a lot of the reservations restricted you from moving off reservation. There was a restriction. You didn't have your nomadic ways where you were out and subsistence hunting. And we were dependent on those rations. We had a lot of people starve to death. We also, during this period of time, had a lot of smallpox. We had smallpox. Our reservations were basically containing that. And I know that at the time of allotment, the Crow people had diminished from around 10,000 people to down to the time that they did allotment, they only had about 1,000 adults. So that was the diminishment. And a lot of our, so the United States is looking at all this and saying, oh my gosh, look what we did. We put these guys on a reservation. We stopped them from hunting. We are giving them rations. They're freezing to death because they don't have heat and all. They're also starving to death. We got to figure something out. That's what they thought would help us, is this allotment. They were going to turn us into farmers and ranchers and do the allotment. Yes, it's devastating. I mean, the whole allotment is horrible. Okay. So what are the general provisions of the allotment movement? It authorized the allotment of the reservation. So they took your whole reservation that you all owned communally, and they were going to allot particular tracts to Indians that were enrolled. Lots of problems with that. We always forget to mention, we'll mention it now. This is where